Before I turn it over to our first panel, I'd like to make just a few introductory remarks. The first is a thank you to a number of people who have made this symposium possible: our administration, the support staff here, the panelists who have flown in or driven to the conference today, as well as Rachel Yu and Angela Wang, who are the symposium directors and did much of the planning and work that led to today's events. A few other brief comments. For those of you seeking CLE credit, the sign-up information is available at the registration desk outside. If you didn't receive it before, you'll need 2 forms in order to make that happen and to have signed up here. For those of you on your laptop seeking wireless access, the brochure that all of you have has the information about how to get it. And for those of you that are here seeking food, we have coffee outside now. I apologize for not being sooner. We're going to have coffee continually throughout the day. There'll be a lunch after this first panel. And our plan is, what we'll do is we'll have a break briefly for lunch. Everyone can go out and get food, and then the keynote address will happen. If you have any questions throughout the day, I'll be around, as well as our symposium planners, and they'll introduce themselves later in later panels, and you can ask us any questions about any of these topics. So our first panel is on social media. Our moderator is Julie Ahrens. She is the director of the Center of Internet and Society here at Stanford Law School. Previously, she was an attorney at Kirkland & Ellis here in the Bay Area, San Francisco, and she has extensive copyright litigation experience and is well-liked within school, and I think will lead an excellent discussion panel here, and I'll turn it over to her to introduce the rest of the panelists. Thank you.
Thank you. Good morning. Thanks for joining us. Yes, my name is Julie Ahrens. I'm actually the director of copyright and fair use at the center, not the actual director of the center. The center does lots of interesting stuff, one component of that being the copyright piece. And today on our panel, I'm going to let our panelists introduce themselves, but we have Carl Johnson, who is here from Brigham Young University, and we have Leela Bailey, who is a fellow at the Berkeley Law School. So, Carl, would you like to introduce yourself and tell us what it is that you do and what brings you here?
Very good, thank you. Carl Johnson. I'm the director of the University Copyright Licensing Office. In that capacity, I deal with all copyright issues that arise across the campus community. I attempt to help and assist the campus community working through the challenges and copyright issues that arise in the university environment. More specifically, I'm the designated agent for the university for DMCA notice and takedown activities. And specifically, I deal with licensing for electronic reserve in the library environment. A lot of library digitization projects come to our attention, and we deal with all the copyright licensing office in the sort of mass digitization projects. Pleasure to be here. Thank you.
Thanks, Carl. I am Leela Bailey. I am a teaching fellow and supervising attorney at the Samuelson Law, Technology, and Public Policy Clinic. In that role, what I do is I supervise student attorneys. So they are law students who are fully acting as attorneys for clients in the public interest in technology law. I mostly have done projects in copyright, having to do with some sort of mass digitization questions, some sort of international policy around fair use for libraries projects. Yeah, any number of interesting projects, big data counseling project as well. We also do a fair amount of privacy work, and I think I'm always quite interested in how privacy issues and copyright issues, especially in the world of social media, come together and sometimes overlap and create tensions. In my former lives, I was also counsel for Creative Commons, where I mostly worked on open educational resources, and I am also the designated agent for Peer-to-Peer University, which is peer learning, an open peer learning platform. We've actually never received an EMCA takedown notice, so I've never actually gotten to respond to one, and hopefully that will stay true forever and ever. Yeah, so that's my background.
Okay, great, thanks. So today our panel discussion, the topic we've been given is just social media. So we're looking at really how do digital copyright issues, either hinder or facilitate social media. I think a lot of the explosion of a variety of websites and different ways that people are social on the web can be is in large part due to the way that copyright laws allow, provide some safe harbors, and we want to take a look at that and also understand what are some of the challenges that sites are facing, as well as looking at, kind of emerging norms and what's happening in this space, and maybe how, people are operating outside of any strict kind of sense of what is copyright infringement or what isn't. And so we'll talk about all of those things. One thing I just, kind of framing, if either one of you want to jump in here and talking about, what is it that we mean when we talk about social media? I think a lot of, obviously there are a lot of words that just get bantered around, but one thing that, strikes me looking at these issues is that a lot of stuff we're like, well, Google does this and Google does that, and Google's not necessarily what I would think of as a social media company per se, but there are probably lots of functions that it does that include that, Google Plus or YouTube communities. And so we could just get, kind of just some general framing around what is social media.
Sure. So the way I think of social media is really goes back to what is now probably the very outdated term of Web 2.0. But for me, social media is just basically participatory communities where we're not just watching TV, we're not just passively receiving content that is being broadcast to us, dictated on high from big companies, but rather it includes conversations among peers and people being able to comment on content that's either created by big studios or big record labels, but also content created by amateurs and other people that are just in their community. And so for me, the idea of social media really has to do with participation and democratization of the distribution channel that is the web.
Very good. Well, to me, social media, in the broad sense, is we all belong, we're all part of a society, a culture, contacts, so forth. And so when I think of devices that I have, and the beeps that I get on these devices can be anything from a few minutes ago, it was called from my local bank and a loan that I'd signed for that the payee, which will be unnamed at this point, that is, I'm the co-signer, and so anyway, that's a business transaction. But in the process of dialoguing with that person or sending information, since it's a local community person, a person that I know, they say, hey, how about if I send you something about this or that? So anyway, my point is that social and media formats, devices, to me, it's all, what can I do with this stuff legally? Whether it's a social media platform, Pinterest, Twitter, whatever, or if it's a text that you attach a photograph that either you took or someone else took. Is it okay? Does it work? Is there a possibility of infringement? Is there a possibility of liability involved in that? So that's my comments about the general framework of social media and copyright.
Sure. And so one of the issues I've seen come up lately talking about social media and copyright is just talking about who who owns the content that people post, let's say, either on Twitter or they're posting on their Facebook page or Instagram, for example. And so we've seen some pretty high-profile examples lately of the user community backlash against specific policies or perceived change in policies. So I wanted to talk about that a little bit, just as like understanding the ownership obviously is a basic issue, and whether there's going to be a copyright dispute or something. And so let's just start with the example of Instagram. I don't know how many in the audience are familiar with the change in their proposed change in policy that happened in December of last year. And by the way, I forgot to mention at the outset that if you want to ask questions while we're talking, please do, or if you have particular experience with these topics, we're more than happy to hear it and have more than our thoughts on these things. And so I don't want to leave it to be like a Q&A at the end, so please feel free to interrupt or approach the mic, though, for questions so that it can be part of our audio and visual recording. So just to back up to the Instagram, blow up in the media, there were a few proposed changes to Instagram's terms of service, and it was pretty controversial, which was actually like less than 24 hours between when the proposed changes were announced and when the media got a hold of it, that Instagram backed down and changed their mind about what they were going to do. But I just wanted to talk about what those proposed changes were. And apparently, from what I understood, the proposed policy that Instagram was going to put into effect would have allowed, instead of having a limited license to what the users had posted to their Instagram accounts, that Instagram would have a transferable and sub-licensable right to be able to use that content. Obviously, Instagram being a photo sharing site, we're talking about people's photographs. And then another proposed section allowed Instagram, actually, which is owned by Facebook now, so Facebook, to charge money. So it said that either another business or entity could pay them to display your photos in connection with paid or sponsored content or promotions. So people really, looked at this pretty harshly as far as all of a sudden you've posted all of your photos to Instagram and now they can be used, Instagram wants to use them in their own advertisements and not pay you or even ask you, that just by using the service you were granting them this pretty a very broad license and kind of a blanket license. So just want to talk about those issues and we'll take a look at a couple of other terms of service. And Carl, I mean, in your experience at the university, or in general, do you have an experience with people understanding what it is they're agreeing to when they use these sites, or that kind of thing?
As to the point of understanding what we agree to, I think we're all part of a click-through culture, and in my there's those of you old enough to remember that an insurance contract or a sales contract is presented in your home, and you say, I'm signing up for several $100s, and oh, by the way, here's a form, and let me just review the highlights. I mean, we don't ever read the community, the populace never reads, and therefore would not understand. And so now, drill down and say, okay, those of us who do read that, our attempt to help others understand what's there, I think it's the devil is in the detail, because in one paragraph it will say things like unlimited broad language relating to a very broad use, and you don't know if that's how long it is. You have to find another paragraph, sometimes 5 or 6 paragraphs away from that language. it's very, very difficult. And so I think the challenge is in terms of our application of copyright and application as a user, as a person intersecting in the digital world, in social media. We just have to do our best and kind of trust that, well, things, that case or that headline sounds kind of bizarre, but gosh, I'm still receiving stuff, and I'm still able to sleep at night, and whatever. In other words, the world just kind of moves on. So that's my, hopefully not too broad, or but as a practical matter, I think things just move on. At the university, more specifically, my role, we have a lot of times when we show up at the student union building and we have a copyright table and students come by, we have things to hand out to get them to come by or whatever, but anyway, the dialogue is healthy in that environment because they can ask, you know, what about when I leave home, I've got all this music library that really my parents bought, but now I've got whatever, 5,000 titles. Is that okay to take it from my house? And the more perplexing question is, how can I tell if a site is legal? When I start, you know, there's a promotion and things seem to be okay, but then I find out it's a bogus site, or I get a notice from you that you've got a copyright infringement notice that came as a notice and takedown. What about that? How can I tell if something is okay? And my commentary is that it's very difficult to know.
Right. So I think you're making a really good point. Which, if we back up a little bit and think about, even 10 years ago, your average person didn't have to know anything about copyright law. Copyright law was for lawyers somewhere far, far away, and it did not interact with your everyday life at all, right? And today we live in a world where we are interacting with creating, consuming, sharing, moving around copyrighted content all the time. And I mean, already today, I probably technically violated copyright law probably 3 or 4 or 5 times, right? Like, we probably all have. And so I think one of the challenges that we as users, as the user communities of these sites, but then also the sites themselves have, is to sort of make this area of law, which historically has been very much to the side of everyday people's lives and sort of not a general part of things, and has a lot of very obscure and complicated and sometimes counterintuitive rules, to figure out how to translate that to, you know, what you're doing in your email or on your Facebook page every day is really challenging. So, you know, as somebody who has drafted at various law firms like hundreds of these terms of service, the companies really want to be communicating what they're actually doing, and what they might also want to do. And so I think that that's what was going on with Instagram. And oftentimes what happens with companies is their lawyers are really trying hard to give them room to move, to do new things and to experiment. But if your terms of service or your privacy policy says, we will never share your data with so-and-so, or you own your content and we'll never sell it, well, they're providing you a free service that you use and you love and that you formed this wonderful community in, but they somehow need to figure out how to meet the bottom line. And so what they're trying to do is figure out, well, so what can we do to make money, to keep our users happy, and to not violate copyright law? And those 3 things often are just in tension with each other, and it's quite a challenge. And I think one of the things that's important to know and note is that I've never seen a I haven't looked at every single terms of service, obviously. I often click through without reading them, even though I'm a lawyer. But I've never seen one that says, we are taking ownership of your stuff. They never say that. What they say is, you own your content, but we get the world's best license, right? Basically, the best license we can think of that will be flexible and allow us to do anything we want with the content that we can possibly think of in the future, anywhere in the world or maybe in space. And they just try to give themselves all the room that they can to be flexible and create new tools and new exciting products for their user base. And so, it's interesting to me how we are now in a dialogue with companies about what these terms are, right? Like, we can think of terms of service as contracts of adhesion, which is the lawyerly term for take it or leave it, right? Sign this or don't use it, right? Which is how these things are presented. But at the same time, if enough of the user community says, hey, hold on a second, we actually really don't like this, companies are responding. And, they don't always respond exactly how we want them to respond. But I would say, like 99% of cases, the companies are trying to act in good faith. And they're not trying to steal your stuff, but they're trying to figure out how to do cool things and innovate and make new cool stuff for you that they can give to you for free. And the way they can give it to you for free is by selling your photos or something, right?
Yeah, I think what you raise is raises a couple of important things. One, it's just interesting to think about the fact that we know about these terms of service and they're being discussed is because these services exist in the first place. So you got this whole blow up on Twitter about Instagram's, terms of service, whereas before you might not, in other contexts where you wouldn't have a community to complain about what your insurance policy was sticking you with. But I think there's a couple of things that are happening that I see trends and terms of service. And so I'd like to look at a couple just as examples to kind of look at the language, see if we can figure out, like, is what happened with Instagram, was the problem that they got too specific or they were too obvious about what they were going to do? And if they had used more general language, could they have given themselves the room to do exactly what everybody kind of flipped out about? And obviously, as the consuming public, you want them to be as clear as possible and describe what they're doing, but at the same time, you can understand why vagueness gets them much farther than being more specific. So I've pulled up a couple, one being the Twitter terms of service. And one trend that I've seen that you can see here, is this mic on? No. Okay, I'm not sure if that helps. Okay, so here the basic, these terms of service. One thing that I've seen on lots of websites, particularly social media, and I think this is geared at the fact, getting to Carl's point, that you're talking to a wide range of people, and some of them are very young. What they've been doing is boiling down, like they have these long paragraphs of what what their actual terms are, and then they boil it down into kind of, just jargon or street talk, where people are like, okay, I get what you're saying. So you can see here on the Twitter terms of service, they have their basic terms and what that is, and then they can sum it up in a one sentence. What you say on Twitter may be viewed all around the world instantly. You are what you tweet. So it's like it's trying to cover both the lawyers, put in every word you can so everything is covered, but at the same time actually communicate information to your users. So I think it'll be interesting to see if there are any developments about what these little boiled down nubs mean compared to what the actual terms are, and if there's some conflict of understanding. Yeah, you have a question?
Is there a disclaimer that these boiled down nubs are for illustrative purposes only, shall not affect the interpretation?
Yeah, I actually, I didn't read through all the long terms at the end to see if that's the case, but I haven't seen that. But I mean, yeah, exactly.
They do have that. Yeah.
That the actual, some of them do.
Yeah. Well, I think one of the, so can I just, oh, sorry, I didn't want to, are you finished?
I was wondering if they did.
Yeah.
Some definitely do have that.
Point of view, I would put that in.
Yeah.
Right.
Yeah. Well, so.
On the Blake's point of view, that's the part of the highlight.
Uh-huh.
That's the part
Right. Well, this is right. This is what you right. Yeah, well, so I just wanted to give a shout out to what I see as the people who started this trend, and there are a number of Creative Commons folks in the audience. And so what Creative Commons was able to do really early on was create what they called a human readable version of their very lengthy and copyright terms, right? But what they were able to do is boil it down to just a couple of bullet points on a page so that people had a sense of what they were agreeing to without having to go to the long, what they called, I think, the legal code. There was the human readable deed and then the legal code. And so I actually think it's great that other companies are kind of jumping on this bandwagon of human readability, right? We don't have the drafting rules that there are in other countries. So Australia, for example, has plain English rules where you're not allowed to use a whole lot of legalese that people won't understand in your contracts. We don't have those rules, but I think what's really interesting is that we are seeing companies interested in figuring out how to translate these very complicated legal ideas into little nuggets that people can take away and really understand, okay, I'm generally agreeing to this concept. Now, how accurately they are doing that is something I have not assessed. And so I think that's an interesting question about sort of what the company might be opening itself up to. You do that with?
You do that with headings.
Right.
Headings, yeah.
Yeah. Yeah. So looking at it as an example, the rights on your Twitter account that you are, this is getting to precisely what Leela was saying. I'm pretty sure this is the section where it's.
We don't. There's a.
Oh, maybe one of our students can. Here, we got somebody who.
Right, it's a little complicated.
We can't just have a,
Maybe the other way.
light switch. So, okay, so you can see here where in this section, the second paragraph, that you agree that this license includes the right for Twitter to provide, promote, and improve the services, to make the content submitted to or through the services available to other companies, organizations, or individuals who partner with Twitter for the syndication, broadcast, distribution, or publication of such content on other media and services, subject to our terms and conditions for such content use. So, and then, the call out being, linking to a whole nother page of rules, but that has to do with, the partners that use Twitter's API. But, that they, so what does that mean? And how different is that from, saying we can use it for advertising, or we can't, or we can, somebody else can use it and you're giving us a license to do that. And so it's interesting. I think that the point being that you do own your content, but you are also at the same time giving them a non-exclusive, worldwide royalty-free license to do what they want with your content as well, is an important thing to think about. And so. So I don't know if anybody here is an expert on how these contracts or how these terms of service have been interpreted, but it's just interesting to think about whether these specific, these more broad terms do things that are any less suspect than what Instagram was, called to the mat for when they got pretty specific about what they wanted to do with content. So another, and then also in the terms of service, obviously they they have a copyright policy, and they lay out what their copyright policy is and what you, are agreeing to, and how to deal with what the next topic we'll talk about, just DMCA policy, and this is an important part of complying with the Digital Millennium Copyright Act, and being sure that you are. Or that Twitter is trying to make sure that they qualify for the safe harbors that exist within that statute. So these are their important parts. So turning to another company, another social media site, Pinterest. Obviously Pinterest, business model built on pinning links to lots of other websites and copying photos and other kind of like snippets of information from all around the web to your page, their terms of service are also very important. And Pinterest, like Twitter and other sites, has the more simply put box on the side demonstrating what their specific clauses mean. What I found interesting when I looked through this, was this part about your content. And, they allow you to post your content, photos, etc. You otherwise make it available, and you retain all rights and you're responsible for your content, but you also grant this non-exclusive, royalty-free, transferable, sub-licensable, worldwide license to use, store, display, reproduce, repin, modify, et cetera, et cetera. And so, these, this doesn't seem all that different than the language that was, highlighted in the Instagram dispute about sub-licensable and transferable, and, so what is it that they can do with your content? And the more simply put boils it down to, we can show it to people and others can repin it. Is that all they can do? I don't know. These, and specifically, if that more simply put box is intended to summarize points A and B here on how Pinterest and others can use your content, it seems to me to be intentionally vague and for the purpose of, giving a broad, scope to what they might do in the future. Sure, you have a question?
Yeah, just a quick question. I'm curious why it doesn't say that it's a perpetual license, right? It's just a.
Mm-hmm.
So it'd be interesting to see if you're a member and you upload something and then a month later you terminate your membership.
Right.
The license continue, or does it come from?
Yeah, and so in the next section, it's talking about what happens if you delete your content and how long they will keep it. A commercially reasonable period of time. So, they may have obligations, legal obligations to keep, data for a certain period of time, or, that obviously they're backup archival audit purposes.
So but does that's interesting. I wonder if the courts have tested what a commercially reasonable period of time is.
I'm sure that particular phrase shows up lots of times in contracts, and I'm sure is subject to lots of court opinions. What it means maybe in this specific context, I'm not aware, but I'd be happy to hear if anybody else is.
Sure. No, I don't. I have another question.
Oh, okay. Yeah, go ahead.
It also says modify and create derivative words.
Right.
I should say I'm not a lawyer, but what does that mean? Because that seems to be incredibly broad and to potentially allow for all sorts of stuff.
Yeah, I think
That's
that
accurate.
yeah, that is accurate, and why that wouldn't stop them from creating ads based on content that is yours or that you have created. It doesn't strike me as anything that's specifically prohibited. They haven't limited their purposes. So sorry.
In which case, it seems to me that somebody who's really concerned about their IP should be really careful about doing something like this.
Sure. Yeah. I mean, yeah. The point being that these are the term. People wonder like, well, who owns it and what can I do? And these terms of service are the way that relationship is dictated. And so the only way to if you are particularly concerned or you have those questions is to figure out what this means, and to the extent you can or can't figure that out, choose and decide accordingly. I think a lot of backlash has come to the point that they don't necessarily, it is, like Leila said, an adhesion contract, and not in the sense that you can negotiate these terms. And so if your choice is to be left out of the social media experience because you don't agree with these things, well, that doesn't really seem like much of a choice at all to a lot of people. The other point is, but this, the other point being that, community, as a community and as a collective voice about these things, and the fact that if users are much more vocal and much more aware and on top of it as far as what these policies say and what they mean. And I think that is also a trend we're seeing, and obviously, traditional media covering these and educating people and lots of people talking about it is also helpful as far as getting the leverage that you need to dictate that you don't want, the commercialization of your photos and that kind of thing.
Well, so I think that's an interesting point, because I think some people think, well, gosh, these terms mean that anybody can do anything. And that's not what it means, actually. It means the company can do anything with your content. Well, not anything, but what it says there, which is very, very, very broad, right? But there was a recent case where the AFP, which is a French newspaper, used some images. This is the AFP versus Moral case. Used some images that have been posted to Twitter in a newspaper story about the earthquake in Haiti. And the photographer who had originally posted those to Facebook to Twitter, didn't like the fact that his photographs had been used. I believe they were used without attribution, et cetera, and so on. And so he sued. AFP fascinatingly argued that because it was posted to Twitter, it was free for anybody to use for any purpose, including commercial purposes, which I find, again, sort of a very interesting position for a newspaper who certainly wouldn't agree that if a newspaper article had been posted to Twitter or Facebook, that it would be able to be, freely reproduced for public purposes or for commercial purposes anywhere on the web. But anyway, they made this argument that Twitter's terms of service meant that anybody has, any Twitter user can go ahead and use twit pics or photos that have been posted to Twitter for commercial purposes. And the court actually disagreed and said, well, no. The company has some rights here, but that doesn't mean every Twitter user in the world can take a Twitter photo and use it and exploit it for commercial purposes. So they're not unlimited, but they are incredibly broad and obviously give the company very broad rights with respect to the content. So I'm seeing a lot of hands. What would be really useful is if people could queue up at the mics, because again, not everybody in the room can hear you if you're just talking to us, and it won't be caught in the audio recording. And then it will be easier for us to keep track of who wants to talk.
I don't know. These terms seem to suggest that the user does have ongoing rights. Maybe that was everybody's question, right? So it says after you delete your account, whatever content your friends may have shared, they can use, freely distribute, modify. So I don't know if the Twitter terms are similar, but
they might be different. I haven't compared and contrasted, so I don't know. All I know is that the court in that case said that the commercial exploitation on in a separate website was not appropriate under the Twitter terms of service. So I don't know what Twitter. I don't know if Twitter has subsequently changed its terms. I don't know if Pinterest uses similar terms or different terms. I haven't looked at it, but sorry, Carl. Go.
I think most of you would recognize that the licensing going in from the user, from the person who posts, is one layer of licensing. What the company says about the user community being able to do with that content is another layer. And we'd have to look at the paragraph as to what the company, the site, is granting to the user community.
Yeah, so it will be determined by that.
Yeah, I mean, here it looks like the site actually has fewer rights. Upon termination, right? It can hold, can retain your content for archival purposes, but not commercial purposes. But if your friends used it, then it can go anywhere.
Right. It's not going to. So basically, I think that what they're saying there is, if somebody has repinned your pin, just because you delete your pin, they're not going to delete everybody else's repin of your pin.
Right.
That's how I read that. But again, what's interesting is when lawyers are trying to draft language that allows for a very specific purpose that they know their company is doing, sometimes they accidentally give themselves or their users a lot broader rights than they maybe have meant to. And so I think we'll see more court cases about this stuff,
sure.
I'm sure. And we will know more about what they mean once the courts have told us.
All right. Thank you.
Yeah, thank you. Over here.
Hi. So in this case, I guess what AFP said, what the court did not agree to was that just because you're a member on Twitter does not give you the right to use the picture that some other member posted. But would it have been okay if Twitter said, okay, we give you the permission to use this, because the court said you don't have the right, the company has the right to do other things.
Yeah.
Does that make it right? Have there been cases where...
I don't know of any cases, but I am pretty sure that Twitter's terms of service would have given Twitter the right to sub-license to the AFP. I think that is probably how broad that is, but I don't know. I don't think the court addressed that, unless somebody else has read that opinion.
And I had a follow-up question,
Yeah.
I think, which is probably a more general question. In all these terms of service, especially for any social media site where most people, and I'm guilty of it, I'm a lawyer and I don't read it. Facebook, click, click, click. Yeah, I want to be a part of that community. It's, in a way, it's like a fine print or a contract of adhesion, like you said. Do the courts really enforce such contracts, or do they really see if all the clauses are reasonable or not? Does the court do the work of a lawyer in that case?
So it depends. It depends. There are differences in court opinions between what are called browse wrap agreements and click wrap agreements. For some reason, courts think that you clicking to agree is a different thing than the terms just living somewhere on the website that you could have clicked on. Sort of the click I agree is viewed as sort of your electronic signature that you have read and agreed to. And usually those are more enforceable terms, although browse wrap agreements have been held enforceable. If the terms are what is called unconscionable, right? If the terms are just not okay, courts can say that's not enforceable. We're just not going to enforce that arbitration clause. For example, arbitration clauses are one that have been struck down in a number of contexts, or like anti-class action clauses. So sometimes courts say that's just unconscionable. We're not going to enforce that. But for the most part, things like this, the sort of like we license you to do this and X, Y, and Z. I mean, I haven't read every single case on this, but most of them they usually respect
Enforce the
and
terms.
enforce the license terms. Yeah.
Thanks.
Yeah, you're welcome. Thank you.
Maybe this is more of a comment, but I want to point out that these websites have to have something like this, because if you look at the internet being a form of publication, the purpose of it is to take information and republish it to other people's computers. So if there's not something, the company can't exist.
You're right.
And people ask me about it occasionally. I go, well, you know, that's what the internet does. It publishes things. So if you don't give people permission, any of this permission, you're opting out of the internet. And you should, you know. Now, these are very broad. I am not seeing, yes. Oh, yeah. This is very, very, very broad. But at the same time, saying that, oh, I do not give you permission to republish anything I put on the internet,
the internet
doesn't actually work.
Right. The internet couldn't function if they didn't have some rights to republish, make copies.
Exactly. And a lot of the license language is precisely to function the way the service is supposed to function. You know, Twitter has to, you know, copy and repeat things that might technically otherwise be a copyright infringement, and so without a license, you know, they're just, you know. And then license is necessary for a lot of those behaviors.
I just wanted to bring this up as something important to discuss when these things come up, that the reason it has to exist at all.
Infinite liability, right?
Right.
Infinite liability for the companies. They could not live with the risk if they didn't have these licenses. So.
Thanks.
They don't need to be so broad, I agree, but they need something.
So it would seem like, you know, assigning a license and a copyright, especially one that maybe is exclusive or worldwide, gives you rights to derivative works, maybe the right to enforce these copyrights and litigate against people. It would seem that a click wrap agreement would be a little better than a browse wrap agreement, because I'm guessing that most of the people who use Pinterest have no clue that they're assigning a copyright. And so that's just a comment. Would love to hear your feedback on that, but I also have a question or two, which are simply that when does a license become an assignment? I mean, if you assign all your rights in a copyright, isn't that an assignment? Doesn't copyright code require a written instrument of conveyance?
So you have to have a signed writing
Signed by both
to make an actual transfer.
But
these are not transfers.
yeah,
these are licenses.
But when does
They
it
are
become a transfer, I guess is my question.
They're non-exclusive. So if it were something that, I'm sorry, do you want to get up on the mic and talk? Okay.
At some point, it becomes a transfer, is my point. Even if you call it a license, it becomes a transfer if you give up all of your rights.
But you haven't given up all your rights because you still are the owner as well, right?
Well,
so,
it depends on the terms of service, but some that I've read do give up, it seems to me.
I mean,
rights.
In that
depends on the
case, yeah, it seems like it wouldn't be enforceable, but Carl.
As a non-attorney, let me try to answer that. I think of it in terms of ownership. That's what copyright is, the ownership of exclusive rights. If I'm transferring it, I'm assigning my ownership. The example that I like to use is, well, I have the keys to Aunt Helen's cabin. I'm as if I'm the owner, but I can't transact that property, that real property, as an owner. I have a lot of uses of it because she no longer lives in the area. She's fine with me maintaining it or whatever. I have keys, I have access, but I don't own it. That's a privilege. I have a licensed privilege to come and go into that real property. Likewise, in terms of intellectual property, it's ownership and then a use privilege, which is I think what you're asking about. So in framing the question, and the answer is, to me, is always, what do I own that I'm transferring the ownership to someone else? That's ownership and transfer, assignment, etc. If I'm going to get a use privilege from someone else that owns it, that's a privilege, a license, permission, etc.
And I'll just point out that, like, for example, so the difference is very, obviously the language is the key part. That in Twitter gives you a personal, worldwide, royalty-free, non-assignable, and non-exclusive license to use their software, and that, so you understand, like, the difference between that and saying I assign to you my copyright in this work, and that's different.
I understand that.
Yeah, so if I would think that if a terms of service tried to say, you hereby assign me the copyright in all of your works that you post here, that because it doesn't conform, if it doesn't conform with the writing and the other requirements, that it doesn't actually do what it says it's trying to do.
Is a click a written instrument?
I don't know. I was actually going to try to look that up because I thought that question was up, and I didn't have time to look that up.
I'm a litigant in a case actually that's dealing with that right now. It's not really it's not really established. But the question is, does it comport with e-sign? And the fact of the matter is, a click, in my opinion, doesn't, but an electronic signature does.
Right.
It could
qualify. But I'm appealing a bad ruling in the 9th District on that, actually.
Well, why don't you let us know next year how that comes out?
Publish that in your article.
Yeah, exactly.
We should talk. Hi. Well, first, no, I thought that was a brilliant point. Sorry to interject. He just excited me so much. No, when there's a transfer, even a leasehold interest, I think what his point was essentially that if you're giving all the badges and incidents of ownership to someone else, and unlike real property, tangible property, which is zero sum, I can be the only one to have this lighter. That's one of the first things you learn about IP, is that it's not zero sum, and I can have it and you can have it too. But if you're in effect granting the badges and incidents of full unfettered ownership under the guise of a license, it ain't a license. And the law abhors labels. And I hope some of my studio and net clients aren't here, but that's the God's honest truth. So I think that's part of the problem, is that these licenses are so broad that they could be tantamount to not a grant where you're divesting yourself, but you're making the other person, in effect, a co-owner. But the point I wanted to make, too, that a lot of people don't realize about this, my background is in entertainment and entertainment-related IP. I will, what's going to happen is that people whose livelihoods depend on this, script writers, photographers, people actually do this for a living, not mom and dad in the picture at the zoo kind of thing, are going to start not posting their stuff if this is what they have to agree to. Because under this clause, for example, you're giving them a non-exclusive right to do all these things, perform. So if you post a play, they get the non-exclusive right to perform the play. Well, guess what, everyone? When you do entertainment law, what you sell is exclusive rights, and you cannot sell an exclusive right if you've already given a non-exclusive to somebody else. And so because of loose lip sync ships, there's going to be a new thing I'm trying to cook up for my next trial about loose clicks, lose you, I don't know what rhymes, but perhaps the people you're doing business with. But loose lips, but anyway, if you're going to be peppering your stuff on these incredibly black hole, infinitely broad and such gravitational force of your IP, you cannot go to Universal and grant them an exclusive worldwide, because you've already given someone a non-exclusive, because of basically this mechanistic, broad, just not one-size-fits-all cookie-cutter thing.
Right. Yeah. So I think So this is where we get to the point of for artists.
So look for that
artists
litigation.
Have always had to, I think, care about copyright. Your sort of people who are trying to make a living from copyright have always had to know how these things work. I think what we're seeing is there are so many more amateurs now who are entering into these agreements who don't know about copyright law, and they don't know that if they give a non-exclusive license to Twitter, they can't. Then basically they've sort of devalued that particular photograph. Now maybe they're okay with the idea of, I'm going to put up a couple of really great photographs, and I'm going to get my name out there, and then I'm going to sell the other photographs that I'm not putting up, right? So maybe some people are savvy like that, right. and I suspect that some people are, but some people might have this other.
Leads into another, the other part of this conversation that I thought we would kind of get into more at the end, but it's important to talk about, which is what are the emerging norms on these sites as far as how people use their own content, how they view sharing of their content, et cetera. So I'll just give you a quick example. The other day, a reporter called me to ask about, what's going on these websites like BuzzFeed. BuzzFeed produces a list of 12 of the top, slow cooker recipes or whatever. And they've got, links. So they've got pictures from 12 different websites that link then back to those websites. And that's all the BuzzFeed quote-unquote article is. And he said, so I went and I investigated whether BuzzFeed had actually, licensed these photos that they were reproducing there. And I talked to the people who own the photo, of the 12 in this list. And he said, most of them, they didn't give them permission, but they didn't care. They were excited about the fact that their website was linked to by a very popular news feed that lots of people then click to their website. And so I think that speaks to a lot of this emerging norms being, his point was actually that maybe 3 of those photos came from news organizations, and those had actually been licensed, and then the other ones had not. And it's just interesting because it brings to mind this clash of cultures as far as either, kind of the idea that there is a clear, that you must clear everything before using it, and if you don't, you're going to be in trouble, which I think lots of these sites are proving the opposite point. Or 2, that there's a clash between what you guys were just talking about, which is the users who are, professionals who are trying to make a living off of what they're doing, either it's photographs or, written content, et cetera. And so, what are the kind of the emerging norms that you guys have seen, as far as what, what otherwise might look like classic copyright infringement, and it's not leading to copyright lawsuits?
Well, I think just a general principle. Where you stand on an issue depends a lot on where you sit. And what that means is in the context of dealing with risk management or possible liability. We have copyright law and we have contract law, which is what we've been talking about with these illustrations of the click-through or the agree or not agree or just a passive acknowledgement. And then we have the exemptions that are in the copyright law itself, fair use, teaching, library uses, and so forth. And then we have societal practices. And then we have an institutional or an individual thinking about tolerated risk. Like I said, I can still sleep at night because I'm okay. I'm okay so far, or whatever. So I think in the emerging practices question, we always have to consider what is the specific issue and who is trying to resolve it. In the entertainment industry, in the client creator-client context, it's a very, very different discussion than sitting around the dinner table sharing things and saying, gee, hey, Uncle Carl, you're a copyright guy. Are we doing everything okay here? And I decided a long time ago that I wouldn't move my detailed, gnarled, professional kinds of analyses into dinner conversations because I want to have a real life.
I'm sure your family thanks you for that, Carl.
I want to be able to socialize in a way that, I mean, and every once in a while I'm drawn into that. Well, yeah, Carl, I have a garage band and I play at the community center, and you've been talking about a public performance license. I've never heard of such a thing. I mean, he's asking this moral question. I said, you're okay. Let's talk about the food. Let's talk about the last movie we went to. Anyway, my point is that emerging practices are best analyzed in the context of the parties, the vested interest groups, and these areas of law, tolerated risk, and societal practice. There's a study here that I'll bring out and refer to interesting conclusions about what the public is actually doing or not doing according to the survey. But anyway, I'll bring that up. And okay. Those are my comments about trying to grapple with what do I do about this today? What do I do about this client? What do I do about this policy? What do I do about myself? It's a tough questions, but it's always possible to answer the question in the specific context and the specific use that you're talking about.
For a lawyer, you sure seem to know the difference between legal advice and non-legal advice.
Well, I've been, besides not having a law degree, obviously I can't give legal advice, but I can give a lot of information. That's useful.
Yeah. Exactly. It's very useful. Okay, so we've got some people here.
I'm sorry.
Yeah, I have a question about the emerging norms, right? So I think all of this will be tested in the courts, but I think the gentleman over here raised some interesting questions about how somebody could actually be relinquishing their rights. If you think about someone who has already entered into an exclusive distribution deal with a record label, if that person posts their music on Facebook, does that mean then somehow they've modified that agreement? And I think the attorneys know that every single one of those agreements is going to have an integration clause, which will say you can't modify this distribution agreement unless in writing signed by both parties. So does the Facebook terms of use somehow effectuate a modification? I don't think so, but I'd actually really like to know how the courts are seeing those terms, because I'm guessing that they will interpret the terms to be non-commercial use, meaning you can, this broad grant that we saw, I don't think it would be held up as saying, because you posted it on Facebook, a competing record label can take the content and distribute it. I just don't see that, but I don't know. Maybe you can tell me if the...
Well,
I don't think that has come up yet.
the attorneys in the room may have a struggle with this, but the business manager in the room may say that this content, this creative work has market value. So councils, you're working for me, so you figure out a way to get it into the marketplace. And still satisfy the company norms of legal compliance or good contracts. But the legal part of it is just it's a very, very important part, but it's part of a broader picture of many things that are considered.
Yeah, the competing interests. Yeah,
the competing interests.
I think that you do...
market interests and the value of the copyrighted work.
I think you do see that. I mean, as far as what I see, or like the examples, just that, from a business, a business interest may mean, taking a different path than what, maybe legally you might be able to enforce or not enforce, and choosing how you handle that as a business, thing, obviously. Permissive about how your content is shared or reshared, as long as it's attributed to you and celebrated and links back to your site, is exactly what you're looking for. And so even if technically, legally, that raises other potential violations by people, you may not be concerned about that, and that from the your business sense is telling you that that's fine and that's okay.
Right, because sometimes views are a new form of capital, right? So like my video has been viewed on YouTube 5 million times, it doesn't give you money in your pocket. That is definitely true. Unless you've got a revenue sharing deal with YouTube where you're sharing the ad, like you're not making money.
If you got 5 million, you can get that.
Some people do actually care about the fact that people are experiencing their content, and really that is more important to them. And so that's certainly what I see in the world of the sort of open education space. A lot of these open communities, they actually make their money elsewhere. A lot of people are either teachers or professors or other kinds of people who really just want their stuff out there in the world, and they're making their money in some other way. And so for people who are trying to make their primary money on the web, I think they're the ones who probably have to care more about these terms of service than anybody else. Sorry.
Thanks. I'm interested in the role of Creative Commons law and license relative to defining maybe the future of copyright and maybe some specific examples. I asked this in the context of developing World University and School, Creative Commons licensed, which is like Wikipedia with MIT OpenCourseware, both CC. How is CC influencing social media, if at all? Is it a complement? Is it an antagonist? Is it, how will copyright unfold digital copyright unfold as a consequence of CC?
So I think that's a great question. There are way smarter people about Creative Commons in the room, so I will invite them up to talk if they would like to. But as somebody who used to work there, I can say that I think one of the most important things that Creative Commons did was to start a culture of sharing and to turn the conversation away from every share is a sale and everybody who shares is a pirate, and really took the language in the conversation to a different place. And people who want to build a community around giving and receiving and having a conversation can do that in a way that is now legal, right? They've got this way of blessing or whatever, of saying like, I am opting into this other world of copyright, right? We don't want all the rights that the default law gives us. We want to live in a different world with different rules, and so what it does is it gives people this choice. And I think not everybody uses Creative Commons who thinks that way, but I think a lot of these emerging practices that we're seeing, for example, like lip dubs on Vimeo, they're not CC licensed, but the culture of sharing has been sort of developing over the course of the last decade, and Creative Commons has played a huge role, I think, in legitimizing that practice and those communities, even if they're not necessarily even using Creative Commons licenses per se. Sure. So, sorry. Go over here and then Andrew.
Yeah, I hate to derail us from the Creative Commons stuff because I want to hear more about what you think about that. But back to the other piece about licenses versus assignment and all this stuff. It seems to me there's kind of three different pieces. One is what is required by the service to technically provide the service that they're providing, which inherently involves, at a technical level, making copies and doing different things just simply because you're putting these pictures on content delivery networks around the world and things like that, right? So there's a technical piece of what do they, in order to provide the service that they're providing, they technically have to have certain rights to your content, right? A second thing is, in order to commercially make their service viable, they have to have some ability to do something somehow with your content, perhaps, right? In the case of Google, it's put advertising in front of you, right?
Monetize it, you mean.
Right, it's monetize it in some way. But then the third thing is this whole thing about then somehow granting on to other third parties, right?
Right.
So one of the things Google, for example, does not do, which they're accused of a lot, is actually sell my information to other organizations, right? What they do is give other organizations access to me through Google's systems, right? But they don't sell all this information to these other people, right? And I think a lot of the tech companies are sort of thinking the same thing. They don't necessarily want to sell your pictures to, some news outlet who's going to use them commercially. But where does the law land with all of those three different pieces and how to subdivide those? And is there the technical competence in the courts and every place else to be able to deal with that? And to what degree do we have to wait for all this to get litigated out, which is just a horrible mess, right?
Right.
Do you want?
Yeah, I mean, I'm happy to jump. I mean, I think obviously, the third parties piece.
Or Andrew can answer that question.
Yeah. Oh, Andrew. Yeah, Andrew could probably answer better. The third parties piece to me obviously is just a subpart of how do you commercialize, how do you grant yourself enough rights that you can monetize, the service that you're providing and actually, it's free to the users, but, make money and do that. And so, whether that distinction, how to draw that distinction or whether that specific distinction matters so much as just being, like getting back to this point of what are you telling the users and what are they actually knowingly agreeing to. And so I think, that is an important part, and it's something that I don't think the tech companies are, have fully, nobody has really, figured out a way to do that. Go ahead. Yeah.
Except that I know just from conversation, because I live in that world, not in yours. But talking to the people involved, all of them are like, well, no, of course we don't want, this other organization to go and make posters of your, of course we're not going to grant them that right. But yet that's sort of almost what their legalese kind of seems to imply they might be able to do. And so it's not really that they're trying to do it, but it's sort of some kind of disconnect between what the probably technical and maybe not terribly sophisticated business people are trying to get done, and then what the lawyers try to do to protect their clients by giving them sort of the broadest possible. And you end up with this really messy kind of thing in between, right?
Right. So finding that precise language that gives you, that covers both sides, I think, is what has been, the real challenge.
I think Andrew has more.
I'm a litigator who drafts terms of service.
Yeah.
It is a mistake to think of them as transactional documents.
Mm-hmm.
There are two purposes to terms of service. Part one is, here are all the reasons you cannot sue us.
Right.
And part two is, here are the reasons why we may need to sue somebody. Okay, that'll be like the anti-scripting, anti-scraping, CFAA type of stuff.
Sure.
Okay, and because we live in a highly litigious copyright enforcement world, you have to nail everything down. You have to nail down every single copyright right. Because even though I don't think the distribution right applies to the internet, because it applies only to material objects by sale or other transfers of ownership by rental, lease, or lending, I don't think it applies to the internet, but you better get a license to distribute.
Right.
Okay? You better get a license for derivative work, even though transcoding may not create a derivative work. You better get a license to authorize, or else in Australia you're going to be sued for copyright infringement via the authorization prong. So none of this is for anybody to go and take somebody's script off an upload and launch a Broadway play the next year. But you better have the public performance right. And so all of these things are there as a protective mechanism. Was it Yelp? Somebody recently got nailed because they had the right to sell your works.
Right.
Well, the reason for that is that when you're defending a copyright case, because you're running advertising next to something at the edge of the page, somebody will say, you're selling my photograph.
Right. Yep.
And so you want a license to sell the photograph. It's not that you're planning to go sit out on the street with stacks of photographs. So I think this is the fundamental framework that people have to understand to analyze these documents. Thanks.
The good faith.
Excellent.
Oh, you might have missed the beginning what we were talking about.
I did miss the beginning, sorry.
Generally working, I think, in good faith. They are trying very hard to give you awesome stuff for free, right? Like so many of these companies that's what they're trying to do, and their lawyers are trying to give them room to maneuver and not get sued.
That's right, and they're trying to empower their clients, customers, users to do the expected things in a way that's not going to create secondary liability.
There's also, there's the countervailing concern, which is, sure, your original intention may have been to give yourself the right so that you don't get sued, but a lot of what they're asking of their users is, trust us, I'm not trying to sell your photo so someone else can run it as an ad, which is it just seems to be the reality of the situation, that the language that you cannot possibly cover all of those things in the language, and it creates this really tough problem, which is, how do we know that we can trust you, that's what the term means, or that the reason you wrote it in there is the only reason you will use it in the future.
No, that's right. It becomes a branding issue of whether people like this service or not, feel that it is a goodwill-based service. There was one interesting case of unintended consequences of a blanket license involving Video Professor, who gave a license to use the trademark to an e-commerce platform in connection with that e-commerce platform's distribution of the product of Video Professor. Well, then that relationship came to an end. Then Video Professor didn't like what the e-commerce platform was doing later, where the brand might appear, and sued. Well, the fact was, Video Professor had given a license.
Right.
Too bad for it that it was no longer distributing product through the e-commerce platform. It had given the license, so slam dunk victory for the defendant. That becomes a business issue. It may mean that in future licenses, somebody's going to say, well, I'm going to tweak this license, if there's power to tweak it, to say you can use this only for so long as X. And that ultimately is a branding thing. You decide whether to go in with that platform or not in the future.
Yeah, and I think that gets, like the branding idea also gets at this emerging practices kind of a sense of, like, if what we have to do, if the language in these terms of service can't be so precise that we are all sure of what's going to happen or whatever, and that a lot of it is taken on faith, that trust us, this is what we're doing, to the extent those change and those practices change, then people vote with their feet or whatever, as far as using those services or causing the kind of uproar, and like I mentioned earlier, that these tools themselves give us much more of a voice in the first place to be able to kind of come together as a community to say, no, we don't want that, and so maybe those are some of the ways that these tough issues, these thorny issues will actually be worked out, as opposed to everything being litigated and then,
Yeah, I think, right, a lot of companies have to answer for things in the media and not necessarily in court.
Right.
And now we have not seen a mass exodus from Facebook, and how many times have their user community freaked out about one thing or another. So I don't know that people really do vote with their feet when services start to feel pretty darn necessary for your everyday life. But I mean, certainly there are fire drills in the communications department all the time, right? And probably also in the legal department. The companies do suffer when these things happen. It doesn't necessarily mean that they're losing their users, but over time they could erode their brand, and I think that is something that they care about deeply.
Yeah.
Question.
Yeah.
I'm not an attorney, but I work in the startup space. And I wanted to mention sometimes there are side benefits to copyright infringement. And a perfect case would be AMC and the Mad Men characters a few years ago with Twitter. What happened was a fan created several parody accounts, and they did infringe on the brand, the characters.
Do you mean parody accounts? They were pretending to be the Mad Men characters?
Exactly.
tweeting?
So there was a Don Draper account, a Betty Draper. And initially, Twitter had responded to the DMC takedown notice and then took the accounts down. But because of the response and the media coverage, and at the time, Mad Men, the ratings were doing not as well as they had hoped. And after all this publicity, their ratings shot through the roof. So the PR and marketing team went back to their legal team and said, hey, this is awesome. We're getting all this free press. We're getting amazing ratings now.
Was the free press, sorry to interrupt you, the free press you mean because of the dispute or because these people were creating funny parody accounts?
Because of the dispute.
Okay, all right.
And because a lot of the fans that followed these characters were really disappointed that these accounts were taken down. So they actually brought back the accounts. And even to this day, I mean, Betty Draper is still tweeting. I believe her last tweet is hoping to lose weight before the family reunion on April 7th.
Right. Yeah, I think that's a great example of the ways outside of what the law strictly prescribes, or the way people are supposed to act, the way that we can see things that are changing as far as more permissive than maybe any statute would be able to give you the right, but they choose, and you see this a lot with backlash against particular takedown notices or things that come down, and like the press and the backlash against that just makes those disputes quickly go away, whereas maybe before that people were more digging their heels about fights and maintaining and not seeing the benefit of what users were doing with their content.
I found this study that I referred to, just very interesting, and this is produced by the American Assembly, Columbia University. The title is Copyright Infringement and Enforcement in the U.S. Interesting data. Let's see. Large-scale piracy is rare. Roughly 2% of Americans are heavy music pirates. Only 1% acquire these files primarily or exclusively through downloading. 1% of Americans are heavy, only 1% of Americans are heavy pirates of TV or movie content. And another interesting thing is copyright infringement among family and friends. Remember my dinner conversation? Copyright infringement amongst family and friends is widely accepted. 75% for music, 56%. Let's see. Anyway, I bring that to your attention because it's an important piece of understanding the nature of society and what's happening there. But anyway, I'm not sure where we're at. I want to make sure we're going into the wrap up here or something that we want to cover in the next few minutes.
I mean, I think that obviously, it speaks to what's the future, where is it headed, and to the extent of, what we see as like personal use and, you know, family use, or that, you know, those kind of concepts, and how those bleed into what then happens on social media, where you also have friends and connections and that kind of thing, and causes different enforcement mechanisms to kick in, or liability. I mean, one thing quickly, maybe quickly that we can talk about are the struggles that face, you know, if it's, you know, you think it's difficult for the content owner and the user to understand who has the right to do stuff. The obvious, you know, the other piece of this is what information does the intermediary, the platform, actually have about who has the right to do what they're doing and who doesn't. And so you know, one thing we don't have time to go into as much as, you know, we thought we might, which is just the notice and takedown procedure and the liability, you know, the potential for liability for intermediaries if they are not, you know, sufficiently complying with the DMCA and taking things down when they are given the notice. And so I think there's a real struggle there with this gray area of what is required, how much policing, what can the platforms or the intermediaries actually do to prevent copyright infringement on their site. And I think that becomes maybe a more difficult question, but maybe less risky in a world where the users are much more fluid about whether they care about the infringement or whether they're actually okay with it, like the Twitter example, or the example of, you know, I think lots of social media sites that are built around sharing of content where the community norm seems to be it's okay, you know.
So I think something that I am still very troubled by is the sort of rhetoric of piracy in general. Like, I think there are so many different ways of that term has been thrown around and defined. And right, so I don't know how the study defines heavy piracy versus other kinds of sharing that maybe. So I think the problem is that piracy is, or that term is a rhetorical flourish that has been being used and beaten to death by one side of the debate. But what we're seeing is that as new business models are coming out where people can get access to content that they find relevant and exciting and interesting, there are ways for people to make money doing that. And not everybody just wants it for free all the time. Mm-hmm. And so I think this general trend we're seeing in decreasing piracy, which for me, I think most people think of like a peer-to-peer file sharing kind of scenario, because that's what courts have kind of done and said, like, well, that's very, very bad and very illegal. But if you're just on YouTube, then maybe that's not so bad. I don't know. So the courts have sort of mucked around with like how we might think about what technologies are good or bad. So for me, what is troubling in sort of the sort of emerging practices, maybe on the other side of the debate, is the increased enforcement, the sort of campaigns around how evil piracy is and how bad it is for the industry, and legislative campaigns around things like the SOPA and PIPA bills that were proposed and then defeated last year, which would have given even stronger enforcement to the content industry. And I think anybody who works in privacy or other areas know that copyright holders have crazy enforcement. I mean, they have statutory damages out the wazoo. They have companies who are policing their stuff for them. They're initiating private enforcement regimes around this sort of 6 strikes concept, where they can go to the ISP and say, this guy has 6 strikes, and you're going to cut off access to their internet for X amount of time. And I think what we're seeing is that there's a very general trend towards more legitimate services being out there, and my concern is that the sort of hysterical rhetoric around piracy really does refer to 1% of people that will never change their behavior, and really everybody should just be making deals. I don't understand.
Yeah, I mean, maybe Carl can speak to this, dealing, having dealt with in the university system for, close to 15 years, I think you said, Carl. But what it means, because perhaps we're at that point because there was this, huge backlash again, or like an re-education or something of people about, what it means to steal. I don't know if you have a kind of, not necessarily contrary view, but just
no. I have some definite views on that. Fundamentally, into copyright compliance, copyright awareness, it is an individual responsibility. Individual, again, as an individual using materials, transporting materials, an individual working in the entertainment or in the policy business or in the Creative Commons business. Anyway, from an institutional point of view, the important thing is to take the institutional sense of copyright citizenship. Well, what governs that? Well, a sense of honorability or respectability or trust or whatever. Those are kind of human characteristics, but they're also institutional characteristics. And all of that affects, well, in more specifically at the university, and the ability we have to reduce our liability as an online service provider, a provider of a computer network that is actually arm's length from the users. In other words, we don't know what they're transmitting or what they're caching. So Section 512, Notice and Takedown, gives us, as an institution, the opportunity to reduce our liability pretty well to zero. And that's couched in the concept that technology is supposed to be neutral. Technological systems are supposed to be neutral in the sense of they don't make judgments about content. They provide the infrastructure to use or to transmit or post or view or whatever, share the content. So I think the law actually has done a fairly good job in Section 512 with all of its challenges and nuances, pushbacks. As one who has processed hundreds of copyright infringement notices over the years, our position is twofold. I mean, our task, our responsibility in this area is twofold. One is to reduce the institutional liability to zero. That can be done very simply. Either human action or technological action that removes or disables access to content. That's alleged infringed content. That reduces our liability. But as a university, as an educational institution responsible for the education and the welfare of our community, we now shift to an education role, or in the worst case, a disciplinary role. And so what we do is we ask the party to tell us what's going on with this, their side of the story.
Meaning the student?
The student or the faculty member, okay, or the staff member. Mm-hmm. And so that pierces or takes care of I think, at least our legal counsel is satisfied that it takes care of the privacy issue, because we're asking them to tell us what may or may not be happening with their account. And their account could be incorrectly identified as a what am I thinking? As a wireless, what do you call it? Hub that 20 students have access to. It's impossible to tell which one
So Carl,
caused the notice.
So in your experience,
so our role is, let's take it, let's see it. Well, okay, so that's private equipment. That doesn't belong to the institutional infrastructure. We can honestly and very short phrase, thank you, well, whatever. we have removed or disabled the access to the either removed or it has never existed on our network. So, and all the years that I've sent answers like that, short, crisp, to the point, I've never had any of them questioned.
From either side?
From the side
from the
of
complaining side.
the complaining side.
So
when I send it into the users and ask them to tell me what might be going on, there's a variety of answers. And I have to decide how long I'm going to spend on that, how long I'm going to spend on them actually opening up their private domain to me. That's a judgment call that I have to make because I've already satisfied the notice and takedown requirement to reduce the liability.
And you might, yeah, and I think what your experience speaks to is maybe, you know, maybe unique experience in the sense that you are an individual who can investigate further and have specific judgments about the different disputes that come up as opposed to automated kind of knee-jerk reactions to different things. And so I would imagine that you've had instances where you might have to take into account, you know, possible defenses or, you know, the exceptions to copyright infringement that, you know, maybe run counter to whatever the notice is that you've received. But that that I think to me speaks to the importance of having that kind of human judgment role somewhere in the process.
Very good, yes. And yes, it's a very delicate decision to decide what your role is in relationship to the community member,
right,
i.e. the student.
Right. Yeah, and
are you asking them to divulge what has happened and then take an educational role and in the worst case scenario a disciplinary role because the university has codes of conduct, honor code and so forth and so on. And if they've behaved in such a way as a quote bad citizen of the community, then they're subject to that. And so those are very delicate and very I spend a lot of time deciding
it's interesting
how far I go. Sometimes I don't get any responses from the individual. But the IT security people have told me that they have verified that it doesn't reside on my system, our system. Well, so that takes the institutional liabilities to zero. I can't find or I can't get the person to respond. Can I conclude that they're misbehaving, that they're somehow not a complying person to university policies and standards? I can't tell that. So I put that file away and move on with life.
I think it also speaks to the challenges of any kind of platform or space such as what you're describing of maintaining that place of neutrality, and that the idea of the DMCA in particular in giving the safe harbor that the intermediary between the user and the content owner stays out of the fight of whether that is or isn't. I think that is somewhat of a fiction, that cannot be, that isn't the reality of how these things get decided. But sorry, do you have a question?
Well, I just it seems like from a layman's point of view that a lot of the power that is given to copyright holders is, I don't know whether it's technically a correct term, but sort of extra legal. I mean, it's like very little due process. There's very little of anything there that we normally sort of assume our legal system provides us, right? And So as a layman, I look at it and go, how long can this last, or to what degree does this just sort of like eventually undo itself? And again, back to the other question: do we have to wait for the entire thing to get litigated for years and years before we figured out, oh, that was all really a stupid idea in the first place?
Tell your congressperson not to listen to Disney anymore.
Well, how long have we been waiting for a resolution of the Google decision? How long have we been waiting for legislative action on?
And it's a whole false positive problem. It's like you're trying to catch these many people, and in the process are creating these many false positives. It's like, it's crazy.
The world will move on before the courts get to it. Let's just be, right? Like, we've already got the antitrust, we're happy, and we're good.
Yep.
Okay, I think
that's true. We are out of time, and we have our lunch, I think sandwiches outside, and then the keynote speaker in here. So thanks for joining us.
Thank you.
Thanks, everybody.